Sir, the Supreme Court telling the High Courts to decide the bail pleas within 2 months. Your thoughts on it?
So, according to me, especially bail for an under trial, somebody who is yet to be convicted, I feel that a time has come where all courts should be liberal in granting bail. Because what I can understand somebody who's committed a very heinous crime or a gangster who will be a threat to the society at large, or somebody whom you feel will flee justice, who's a flight risk and he may not, come back for trial. Only in very exceptional circumstances should a bail be denied. Otherwise, in every case, and I've seen a lot of High Court judges also doing a lot of good work in granting bails quite liberally, rather than keeping people behind bars as under trials. Because just imagine, till our criminal jurisprudence, very clearly says that till you are actually convicted, you have to be assumed or presumed to be innocent. And in that period of presumption of innocence, if you are kept behind bars and if you ultimately succeed in getting acquitted, then the time that has been spent by you behind bars can never be given back to you. The kind of trauma that you have suffered behind bars, the kind of name that is completely, ruined in society, that can never be given back. Even if you are ultimately exonerated with flying colors saying that you are completely innocent, still the period that you have spent in custody can never by any method be compensated. So I think this jurisprudence needs to evolve in this country, and I think trial courts and high courts, in fact, bails for under trial should not even come to Supreme Court. They should be granted at the High Court level only, except for the exceptions that I mentioned before this. All such cases should definitely be granted bail at the earliest, and that will also ensure that the person's life and liberty is protected and he's not unnecessarily made to incarceration for no fault of his.
There's a particular bail case which has been discussed a lot in the public domain, which is about a point of law about seeking repeated adjournments. Now, can that really be a ground that somebody has not got a bail or has not been given a bail?
I'm really surprised when I saw that clip. Somebody sent me, a former CGI, saying that somebody had been repeatedly asking adjournments while the matter was in the trial court. Now, what he has completely failed to appreciate is that the bail has been rejected by the High Court, and it's a rejection. It's not a withdrawal. It was probably at the initial stages of the trial when the accused was not confident of getting bail, because at the initial stages, all that publicity and all that media trial that goes in these high profile cases, very rarely do these cases get bail in the initial days. But later on, after having spent so much time in the custody, if he is ultimately denied bail by the High Court, then the fact that his counsel had taken adjournment years back before the trial court, I don't think is of any consequence at all. I mean, even to mention that, is according to me, showing a lot of immaturity, because that adjournment at that stage has nothing to do with what ultimately happened after so many years when bail was denied to him by the High Court, and now that the matter is in Supreme Court. So I don't think adjournment of this kind should have any impact on the final decision of the High Court.
Are there other grounds where a bail can be denied to someone for a really, really long time?
So I'll tell you a very interesting case that I did recently. So this was a case where somebody who had been, who was considered to be part of a gang, or so to say, and every time he has come out, he has done some incident. His case was a fit case for bail. But because he was a named gangster in Delhi, the court said that how do we let you go free, and you will ultimately, the moment you go out, you will get into another, a similar act of the kind that you've been accused of doing for so many years. Now, those are the cases where probably, although I don't agree with this view, because ultimately, if supposing he were to be acquitted, because in most of these cases, you will see that very few people come to give evidence, and he were to be acquitted, then you can't still keep him behind bars in spite of being acquitted, however dangerous he may be. So ultimately, you may have to keep him under surveillance if he is released. But those are the cases where courts do deny bail for long periods of time. But the sad part is that in our country, because of the lack of legal help, especially in the lower courts and in the small areas, even today, I know of people who have suffered incarceration more than the full sentence that they would have been awarded if they had been convicted as an under trial. So that's the kind of country we are living in. And there have been several path-breaking judgments of the Supreme Court, where Supreme Court has said that please analyze the under trials who have already completed half the sentence of what they would have been ultimately been awarded, and immediately release them on bail. But notwithstanding that, even today, there are people who have remained in jail for very long periods of time. So I think the only cases where bail should be refused are very, very heinous crimes, or if there is a flight risk and if you feel that this person will not come back, and you should have enough material to say so. Merely your apprehension is not, good enough. You should be somebody like a Charles Sobraj, who used to change his face every day and would had several passports and could immediately, sort of sneak out of the country. Otherwise, it's not easy for anybody to sneak out of this country. So I don't think everybody or anybody can be, termed to be a flight risk. So it has to be also very, very strictly, applied with a very judicious mind to decide whether he is a flight risk or not. And only in those cases, bail should be denied. Otherwise, in all cases of an under trial, according to me, bail should be granted.